is Mr. Swapnil Sanap. He is Principal Associates.
Sir, just be a little loud. What is it?
Your voice.
Just be a little loud.
Okay. Okay, madam. So, Mr. Swapnil Sanap is the Principal Associate Patents of IP Attorneys. He is software engineer working as a patent engineer and having more than 8 years experience in this field. He is also registered Indian patent agent. Being research scholar, he has presented and published more than 12 IEEE research papers. Dear sir, at DYPCOE, we have done more than 300 number of patent filing and publication. Our principal, Dr. Vijay M. Vadai, has awarded with one of the patent from Indian Patent Office. By this, I am requesting Mr. Swapnil Sanap to deliver his speech. Thank you, sir.
Good morning all, and thank you very much for the brief introduction about me and the services that I provide. So I hope I am visible to all, and after some time I'll obviously shift on to the presentation that I have prepared. But before that, I'll just briefly introduce.
You are visible and
Sir, you are not visible.
I'm not audible?
Yes, sir. You are audible.
You're audible, but you are not visible, sir.
Am I visible now, ma'am?
No, sir.
Okay, I think there's a bandwidth issue. So let us continue the audio presentation itself, and then I'll share the slides as well with you. Let me just share it. Just a moment. Is the slide visible to you, ma'am?
Not yet, sir. Have you shared it?
Yes, ma'am. Is it visible now?
Yes.
Okay, great.
Yes.
So I hope the full screen is also visible.
Okay, just put it in the presentation mode. Yes, sir.
Okay.
Yes, sir. It's perfect now. Okay.
It's visible now? Okay, great. So briefly introducing myself, my name is Swapnil Sanap, and I have done my bachelor's and master's in information technology. I am also a registered patent agent and working as an associate partner and head of Pune office for one of the leading law firms in India, Khurana and Khurana Advocates and IP Attorneys. And this law firm, Khurana and Khurana, is dedicatedly involved in protecting the intellectual property rights created by the individual people or the esteemed companies across the globe, so that they secure their innovations and inventions in a better manner. So it has been more than 10 years I'm working in this field now, and I have worked on many projects which involve the research as well as the product per se, when before and after the launching of the products as well. So today's session that I'll be delivering will be briefly introducing you about the what is intellectual property rights, what is intellectual property first, then the rights, and what are the different types of IPR that can be protected for any invention or any idea or concept that comes to your mind. Before going into details of each of these topics, I would like to just suggest and indicate that my presentation is more related to a real-time scenarios that you use in day-to-day life, and the examples also to relate the day-to-day products or the services that you use in your daily day-to-day work. So before going into details, I will just try to explain it with a very simple example in terms of what is the importance of intellectual property right in your life. Now just imagine a scenario that if you bought a kind of car, okay, and as soon as you move out of this showroom after buying a car by paying the payments, and somebody on the street comes to you and say, this is not your car, but this belongs to me. So this car which you are riding, which you gave money to a particular owner, a particular manufacturer of the car, and you bought this car, and somebody just randomly comes and says, this is not your car, but this is my car, get out of the car and I'm going to take your car. What is the best way to suggest or indicate that this car belongs to you and not to the other person who is trying to steal it or take it away from you? One of the best answer to that we see is that we show him the registration book or the document that we have received from the showroom about the buying or selling of that particular product. Now, this is applicable for almost all the things which we see in day-to-day life, which we call it as tangible assets. For example, the flats that we buy, the mobile phone that we buy, the television set that we buy, the computer or laptops that we buy. These are all categorized into tangible assets. Tangible assets are basically those assets which we can touch, which we can see, which we can feel. Now, in contrast to this, there are other type of assets called as intangible assets. These assets are those assets
Hello,
which you
sir.
cannot. Yeah, hello.
Can you just put the slide in presentation mode?
Is this okay?
It's yes, yes, okay.
Okay, sir.
This is in presentation mode.
Yes,
Is
sir.
visible, right? All the contents are
Yes,
visible, right?
yes, okay.
Okay. So I was suggesting that the other type of assets which are called as intangible assets are those assets which you cannot see, which you cannot feel, which you cannot actually touch. So these type of assets are generally created in your mind, and before they are actually brought into existence in the form of tangible assets. Now, how a person can say that this particular intangible asset belongs to me? Because everybody has a thinking capacity, everybody has a brain, everybody thinks using his or her brain and comes up with some or the other concept or idea. How will one claim that this particular idea belongs to this particular person or this particular human being? That is why intellectual property was a field brought into existence to protect or to secure such kind of intangible things that come to one's mind or one's brain. As the name indicates, intellectual property, it is divided into two types. Intellect means human mind or human brain, and property means since it has come to you, it should be your proprietor, and thus the property is associated with it. So you should be able to say that this belongs to me, and this is why intellectual property was the field brought into existence in the first place. Now, what is intellectual property rights is basically the right given by an authorized or a signatory authority to a person or to a human being for his invention, his concept, his idea, or his intangible asset that has come to his mind, intangible thing. Now, this intellectual property is very essential. Why? Because just imagine you keep on researching, you keep on developing, you keep on innovating the things, but after you do a research, after you do a innovation, after you do a development of that particular research and technology, you come up with a product. It is a very beautiful product. You launch it in the market, but tomorrow your competitor or any person who likes the product easily copies it without your permission, without your knowledge, and start selling it in the market or start using it without your knowledge. What is the benefit of that particular thing? You must have invested so much of time, effort, and money in doing research and development for achieving or coming up to a particular product, but you're not able to protect it. You're not able to stop that person from copying it or using it or selling it after manufacturing without your knowledge. That is why these rights, intellectual property rights, are the legal rights given to you by a particular government of a particular country, so that you can practice or you can be able to claim the ownership of that particular idea or concept or innovation, or in other words, for that research and innovation, you should be able to claim your rights on that, and nobody else without your permission should be capable of using or manufacturing it. Even if they do so, you should be able to take a revenue or a royalty or a particular benefits out of this particular concept if even somebody is trying to use it without your permission. And that is why the second most important point, what is intellectual property right? This is what is an intellectual property right: a right given to you by a particular authority or a government for your own invention, your own idea or concept. I am intentionally using the interchangeable term like invention, idea, concept is because I will tell you why in terms of when we go into different types of IPR. Now, in the next slide, I have just shown you the same thing here. Basically, you can see there is a brain and there is a protecting hand that is kept. So basically, intellectual property, that means any particular concept that has come to this particular brain. This brain can be yours. This brain can be any person who is into research and innovation industry. This brain can be of a person who is working in a company. This brain can be of any small child who has just come up with a very good concept of solving some of the real-time problem. This brain can be of any human being, and the hands beside this particular brain shows that a right gives us this particular concept or invention that has come to this particular brain. So intellectual property and intellectual property rights are basically two different things, and the rights are only allocated when The government gives it to you. The rights are not created automatically. Okay, so this is very important thing to understand. Here I have shown a kind of flower diagram where you can see there are different types of IPR. Most of the time, the researchers or the common knowledge that the industrial person has is like whenever we say an intellectual property right, it is always with the patents, but that is not the case. There are different types of IPR similar to different types of fields or branches of engineering. Let us imagine intellectual property right is a domain called as engineering, and the different fields or different branches of this particular engineering are nothing but the different types of IPR. Now, how do you divide this particular fields of engineering, different branches of engineering into multiple categories is based on the subject matter or based on the expertise of that particular field. Similarly, intellectual property rights is divided into so many fields or so many branches based on the expertise or based on the idea, type of idea which has come to that particular mind. Okay, so these are the different types of particular intellectual property right. In a clockwise direction, the first one is the patents, second is a trademark, industrial design, plant variety, copyright, geographical indications, layouts of design IC circuits, and confidential information, also interchangeably referred to as trade secrets. We are going to go into brief introduction about all these different types of IPR, but just for clarity, it is really important for an innovator or a person to identify himself in terms of which particular type of IP your concept belongs to. For example, if I have come up with a very, let us say, an idea for solving some of the problem which is persistent in from a conventional manner. So this particular idea, until it is implemented, it is just in an idea stage because you are not sure to what extent this particular technical inputs or technical implementation details would be required. And hence, it is really important which particular category this particular IPR of this particular IPR, it needs to be categorized. I'm going to give a brief introduction about each of this. I will start with the simplest one. It is called as copyright. Copyright is basically a kind of any particular right given to any literary, artistic, or dramatic or cinematographic work. In very layman term, anything that has come to your mind can be protected under copyright. Now, when I say anything, that includes a simple drawing that you just sitting on a table, you just draw a beautiful drawing of something, maybe of a cloud, maybe of a tree, maybe of an animal. That can be considered as your work, and hence it can be categorized under artistic work of the copyright. You can go and file a copyright for it, and you'll get a grant of that copyright. Other example is you write a research paper for a particular journal, and since it is your own creation, the paper I'm talking of, not the research, the paper that you have written in a manner, the terms that you have used in the paper, that can be categorized into literary work of a copyright and can be filed, so that tomorrow if somebody tries to copy that paper as it is or use that paper without your permission, you can stop them from using it based on this legal right called as copyright. Another example of a copyright is the dramatic or cinematography work. For example, the movies or the songs that we see on a television, these are all somebody's creation, somebody's idea that this person has to act in this manner, and these are the words that he should use while expressing his feelings. So the book, the literary work in terms of any novel or any textbook for any educational purpose, all these are categorized under literary work, and the cinematography work comes into picture when as soon as you try to add an audio or a video to that particular text form. Sorry. Similarly, the presentation, for example, the presentation that I am currently giving, and it has an audio also, sometimes video also, this can be also categorized into a kind of cinematography work or the artistic work, and can be filed under this particular copyright. The best part of this copyright or the protection that it gives you is that you can stop anybody from copying it, from reproducing it, from translating it to a particular extent, and then it also helps you to get a monetary revenue out of it. I am not sure how many of you have seen that the Harry Potter movie. It was actually written in the form of a novel first, and then it was converted into a movie form. So the writer of this particular book, Harry Potter, let us assume a scenario that if she must have not given a right of the copyright person who is producing the movie, obviously it would be a copyright violation, and she could be eligible to sue that particular director or the production team of that particular Harry Potter movie. Same goes with the Indian movie Three Idiots. Chetan Bhagat wrote 5.someone couple of years back, which most of the people in India as well as abroad read the book. And after some years, Mr. Hirani produced this movie Three Idiots, somehow he forgot to take permission for that particular movie from Mr. Chetan Bhagat. And thus, after some days, you must have seen in the news as well that Chetan Bhagat sued Mr. Raju Hirani for producing this movie without his permission, and the movie was completely based on the novel that he has written called Three Idiot. So this is the power of copyright. Now, most of us may not be aware that the copyright is really essential, but yes, down the line you need to appreciate that this is very essential, because the research work that you keep on working, the innovation that you keep on building, the particular drawings or designs of a particular product that you want to plan for future, maybe down the line after 2 or 3 years, that has to be in a form which is represented on a paper, on a book, on a particular document. And thus, if somebody tries to steal it, if somebody tries to copy it, there will be no protection for your concept or idea, which will be produced maybe down the line after 3 or 4 years. And thus, once you create this particular, or as soon as you create this particular concept or this particular idea on a paper, copyright is the most eligible part or eligible type of IPR that needs to be filed. The protection that a government gives, for example, the Indian government gives the protection of a copyright till the life of an author plus the 60 years after the life. So even after the death of the author, the next nominee or the next owner of this particular, or the successor of this particular author, can enjoy the rights of this particular copyright to next 60 years after the death as well. These are some of the examples of the copyright that you can see, and these are on the left hand side. If you'll see, these are the different types of copyright as well, the subtypes of copyright and respective categories of the particular thing. So for example, like I gave an example, literary work is like having novels, diary, poems that you write. Even the research papers, IEEE papers or journal paper, thesis that you write can be categorized into literary work. Musical work includes various type of musics. Choreographic work includes various types of the steps that they have. So these are few of the examples of it. And the last part of the slide that you can see, programs. The computer programs that you see, that you write, that you have for your mobile applications, or for any operating system, or for even your proprietary app, that can all be categorized under copyright. When I say computer program, that means the particular language that you must have written this particular code into, that can be specifically protected under this particular copyright. Moving on to the next simple type of IPR, it is called as trademark. As the name indicates, this trademark can be bisected or dissected into two parts, trade and mark. So any mark that represents trade is categorized under trademark. The best example of this is like any particular name or any particular logo or sign or any particular color combination that gives me an indication of a particular product or particular company. It is called as trademark. Now, best example of this, when I say McDonald's, automatically a burger come into my mind, and there is no confusion with a pizza. In contrast to this, if I say Domino's, automatically a pizza come to my mind and not the burger. This confusion is avoided because these marks, these names have created a particular impact on my mind, and that's why that is called as brand, and such brands are protected under trademark. Also, for example, when I say Apple, nowadays 90% of the people, when we say Apple, they direct it to an Apple company or an Apple phone, and not to the normal Apple fruit that we eat. If I'm too exaggerative, not 90%, but maybe 50% of the people say that when I say Apple, it is always an Apple iPhone or Apple iPad. Similarly, when I say Microsoft, automatically a Microsoft Windows come into my picture and not anything apart from that. Nokia, when I say, this is just a name that I'm taking. I don't even have to say Nokia mobile. When I say Nokia, automatically a mobile phone comes into my mind. So this is what a name or a particular logo of that particular product or a company has created an impact on my mind. So this is what trademark takes care of it. When you also doing your research, innovation and development of a product, when you come across any particular name for your product, the best example, nowadays we are using Arogya Setu app to determine who are the nearby COVID patients in our area. Now just imagine Arogya Setu was an initiative taken by the government of India, and let us imagine, I'm just giving an imaginary scenario. Maybe somebody, maybe some government outside India, for example, Pakistan, or for example, USA, copies the same name, Arogya Setu, and says that this is our concept in United States. Indian government will stop them from using it because they must have already a trademark protecting this particular name for this particular group of people or this particular app. And this is the power of trademark. The bottom line, if you see TM and R, basically once you apply for a trademark, you can start using the TM. But as soon as when the government approves your mark, you can use the term R. You must be seeing this in almost all the products nowadays which are being launched in the market. You can see on the top or the bottom corner of that particular name, either a TM into circle or R into circle is written. Now, the life of this particular trademark is 10 years from the filing of the application or when you submit it to the government for approval, and it can be renewed every 10 years till next three times. That is 30 years is the total life of the trademark. Now, these are some of the examples that I have brought. Now, for example, if on the right hand side, for example, let us say on the bottom row, I see two of the logos there. One is of the, I think, Audi, and other is of the other reputed company. So if you'll see, I don't even have to take a name of the company, and automatically these relates to a particular brand of a car. So automatically when I say BMW, there is no confusion between BMW car and BMW burger. So automatically BMW, when I say, our mind is diverted to a car and not to any other products that are available in the world. So this is what is the impact of these logos, these names that has created in our mind. Now, moving on to the third type of simplest IPR, it's called as industrial design. Now, this industrial design is always associated with the product. That is the tangible things that we can touch, which we can see, which we can feel. So any product which has a particular appearance to it, such appearance is protected under industrial design. The best example of this is the water bottles that we see. The water bottle of a Bisleri and the water bottle of a Kinley, they are different. In just by looking at it, you can tell these are different. Why? Because there is a specific difference in the shape of these particular products. Now, this type of difference in the shape, only the shape can be protected under industrial design. Now, you are working in a research and development industry, and your end result during the development is a product which you can see, which you can touch, which you can feel. So such product has a unique shape. Now, how to protect that shape? Then industrial design is the right candidate for protecting this particular shape of your product. Now, in the earlier presentation, what Dr. Koinkar shared with us, he said that there will be various products which he would be coming up into for the usage in electronics and other domains of technologies. So if a product is being manufactured, as soon as the product is being manufactured, obviously it will be something in shape, and such shape, only the aesthetic particular product can be protected under industrial design. The other famous example that I would like to give for this is, like, you must have heard the cases or you must have read it in the newspaper. Apple company sues Samsung for the copy of their patent. Now, interchangeably, this industrial design is also referred to as design patent. So the shape of that particular phone was copied by Samsung, and hence this particular Apple company sued Samsung. Similarly, in Europe, the shape of that particular product of Samsung was copied by Apple, and hence in Europe, Samsung sued Apple. So this is what is the importance and impact. And just for clarity, just for update, the suit was for almost some $1 billion suit. So just imagine, for a production, how much money they must have invested, how much amount of time they must have invested, and by suing this particular company, they have gained more as compared to what they have invested. That is the impact of this intellectual property right, and specifically industrial design. So here, only the aesthetic appearance of your product is protected. How your product looks from outside and the features thereof are protected under industrial design. The life of an industrial design, once you apply for it, it is 15 years from the date of filing. So one of the examples that I brought here is, like, this is a very good design of a, let us say, a kind of blazer or a coat. This for women, this particular designer has come up with. You see that this may look like a very simple design, very commonly available design of a coat, but you see at the bottom part on the first right hand side image, there is something different particular portion that you see. Now, this coat was brought into existence because when we walk in rainy season outside our houses, our the water from the side part when we walk is actually forced to put on our clothes, and our clothes becomes dirty. So this is the reason that this plastic film or plastic material was put at the bottom of this particular coat, just to avoid the clothes being dirty. So this is why this was categorized under industrial design. Now, it has no functionality associated with it. It has no operation associated with it, aesthetic or ornamental. And hence this was categorized under industrial design, and she is actually currently enjoying the rights for the industrial design patent for it.
Sir.
Hello.
Sir, can you wind up the session within 1 minute?
1 minute.
Yes.
Okay, great. So basically, this is a geographical indication indicates in a particular, let us say, an identity of a geography, which actually gives you a introduction about a product from that particular for particular jurisdiction. For example, Alfonso mango, Nagpur orange. These are all the examples of the products which are dedicated from a particular origin of that particular jurisdiction. Integrated designs are basically the designs which are given for the IC layouts of a particular product. And that's why this particular type of specific IPR is used for this particular protection. Plant variety protection is a type of protection which is given for the variety of plants which are generally different from the conventional plants and which are sustainable in nature. So this is also called as farmer's right. And the next and most important part is the utility patent. This is generally given for the innovation and technology related inventions, wherein the any innovation or any invention which has functionality operations associated with it are protected under this particular patent. So this is very important because it has all innovation and technology related to it. So this particular patent is a type of IPR given specifically for innovations, inventions which solves a particular problem. Now, secrets, this may not be very important for you, but I will just wrap the session with this very simple example. You see, this is an example of a Coke bottle, wherein you can see there are 3 different types of Coke bottle, and different types of IPR are applicable on this single product. For example, the shape of this bottle was protected under the design patent. The contents written on the bottle were protected under copyright. The name Coca-Cola is actually protected under trademark, and the cap that you see, once it is broken, the seal is broken, it cannot be reused or it cannot be resealed, and hence such kind of technology was categorized under utility patent. Also, most important to note here is like the formula that they used to come up or form this particular content of a Coke are categorized under trade secret, which is not known to people. So we don't know what is the formulation of this particular Coke. So I think what is the importance of IPR is not only to give you a protection for your invention or the research that you're doing, but also it is important for in future perspective to generate a revenue out of that particular concept, not only to enjoy the monopoly, enjoy the proprietorship, but also to stop anybody from stealing this particular invention or this particular IPR or the creation of your mind. So I think this is what my session will conclude to, with a brief introduction of the IPR.
Thank you, sir.